All right, let's talk about something that's all around us but almost invisible: public international law. You can think of it as the rule book for how the world works, the code that governs everything from trade deals to human rights.
I mean, think about it. You've got over 195 countries, all with their own interests, their own power, their own agendas. What keeps the whole thing from just falling apart into a constant global free-for-all? Well, the answer, or at least the attempt at an answer, is international law. So before we get into the big debates, we've got to ask, what exactly is this global rulebook? Let's pin down a definition.
What's really interesting is how this whole idea has changed over time. You know, the traditional view, on the left there, was that this was a law just for states. It was like an exclusive club for countries, and that's it. But obviously, the world got way more complicated. So the modern view, the one we use today, is much broader. It includes big players like the UN, and this is huge. It even recognizes that individuals, people like you and me, have rights and responsibilities under international law.
And that brings us to the massive elephant in the room question. If there's no world police, no global government to smack countries on the wrist when they break the rules, can you even call it law? So here's the classic skeptical take. A guy named John Austin, a jurist from back in the 19th century, had a really simple view. He said for something to be law, you need a boss who gives a command, and you need a punishment if you don't follow it. Since the world doesn't really have either of those, he basically called international law a set of nice suggestions, positive international morality, but not real actual law.
But there's a strong counterargument. Oppenheim here offers a much wider definition. He says, look, if you've got a community, a set of rules, and everybody in that community basically agrees to follow them, well, that's law. He saw the community of nations as exactly that. It's their consent that gives the rules power, even if there isn't some global parliament handing them down.
So, after all that debate, where do we land today? Well, the general consensus is that yes, international law is law, but it comes with a giant asterisk. It's often called a weak law. Why? Because it's built on countries agreeing to follow the rules, not being forced to. And that, right there, is both its greatest ideal and its biggest problem. And this really breaks down why it gets that weak label. The World Court can't just drag a country into a case. The country has to agree to be there. Powerful states can often ignore the rules or veto any action against them. And let's be honest, we see the rules get broken all the time, especially in conflict. There's just no global 911 you can call. Okay, so that leads to the next logical question, right? If there's no world government writing these laws, where do they come from? Let's take a look at the actual blueprint.
This is it. This is the official list, right from the statute of the International Court of Justice. At the very top, you have treaties. These are the formal, written-down deals between countries. Right below that is something super important: international custom. Think of these as the unwritten rules. Then you have general principles that are common to most legal systems around the world. And finally, you have court rulings and the writings of top legal scholars, which help fill in the gap.
Let's drill down on that custom idea for a second, because it's pretty wild. For a habit to become a law, you need two things. First, lots of countries have to be doing it over and over again. That's state practice. But that's not enough. The second part is the magic ingredient, something called opinio juris. It's a fancy term for the belief that you're doing something because you're legally obligated to, not just because it's polite or convenient. It's the difference between saying hello to your neighbor, which is just a custom, and stopping at a red light, which is the law.
All right, so we've got these big global rules floating around, but how do they actually make their way down to the ground level and affect the laws inside a specific country?
Well, there are basically two schools of thought on this. On the left, you have the monistic theory. This sees international and national law as part of one big legal universe. If a country signs a treaty, boom, it's automatically part of their own law. Then on the right, you have the dualistic theory, which says they're two totally separate systems. And international law has no power at home until the country passes its own specific law to make it official. It has to be sort of translated into the local legal language. Okay, so after all this theory and all these definitions, let's circle back to the most important question. With all its flaws, why does any of this matter? Because here's the bottom line. For all its weaknesses, international law is the essential operating system for our planet. It's the basic framework that makes global trade, air travel, and diplomacy even possible. It sets the standards for human rights and tries to put some limits on the horrors of war. Without it, our hyper-connected world would have no shared rules of the road. It would be chaos. And that leaves us with a huge, critical question for the future.
When we're staring down the barrel of massive global problems, climate change, pandemics, AI, you name it, is this weak law system, this thing built on the voluntary cooperation of countries, really going to be strong enough to see us through?